Court of Criminal Appeals is now in session. You may be seated. Thank you.
All right. Madam Clerk, you may call the next case.
State of Tennessee versus Brandon Cody Phillips.
Quickly, before the court takes up the next case, I'd like to just briefly introduce Johnny Saraceno. He is a graduate of George Mason University and the University of Tennessee College of Law. He joined our office last fall, and this is his first argument, and we are very excited that he is here today to argue this case, and he just wanted to introduce him to all of you.
Thank you so much, and welcome aboard. We look forward to hearing from you.
Yeah, welcome, General.
All right. We've called the case, and it's Ms. Sammons?
Yes, Your Honor.
All right.
Thank you. I'm pleased to meet you. I'm Amanda Sammons from the Campbell County Bar. If I could reserve 7 minutes, please. Thank you.
Did you say 7 minutes?
I'm sorry?
7 minutes?
Yes, please, if I can. I know it's normally 5, but
Just
add
whatever
to-
you like.
Okay, thank you. If I could try to consolidate all of our briefs into one centralized argument for
Well,
me.
we've got questions about that. I know I do, and I wanted to make sure I understood what your arguments were in your brief. And I guess at the top of my review, I had our issues 1, 3, 4, and 5 the same.
They may be, and they may be different ways.
An answer. What we do, Ms. Sammons, I'm not familiar with you.
Okay.
So it's nice to meet you.
Nice to meet you.
But the way we review the briefs that are submitted to us, we go by the issue statements.
Okay.
Or the issues within your issue statement section. I think it's Rule 27 that talks about that. I'm not sure if that's the right rule, but so the way I prepare is I match the issue statements with the argument section, because what is anticipated is that there will be argument for each issue, okay? Argument, authority, analysis, those sorts of things. And yours got very difficult. I think the next note I have is, this brief is largely in bullet points and difficult to understand.
Oh,
So
I
I need for
apologize for
you
that.
for the judge who will ultimately author the opinion, I need some specific, I guess, answers as to what the issues are.
And I apologize, Your Honor. I'm the same way. I kind of write like William Faulkner, I think. I do kind of stream of consciousness. And when I write the statement of the issues, that's the initial part of my brief. And a lot of times it's not literally until I get to the argument of today that I realize there is a cohesive line of thought that I'm trying to get the court to emphasize and to see. I just may not see it until I get there, and I apologize.
You don't need to apologize. You just risk waiver.
Okay,
by
well,
not doing it the right
I don't
way.
think any of these are waived, but I do think the more important ones are 2 through 5. So if I can skip over 1, I'm not. I think number 1 was a little too general, because I said whether the trial court erred in ruling that proceedings at a hearing on a pretrial motion to sever need not be recorded.
Okay, so issue 1,
Right, and
there is no separate argument in your brief. So
Okay.
Is it safe to say that that issue is waived?
I think so, because I think it's too broad. I'm not asking the court to create any bright line rules by affirming that particular statement. So if we can move on to number 2, whether and that is going to be whether pursuant to the Tennessee Rules of Appellate Procedure, Rule 13E, the evidence with regard to each count of the indictment was sufficient to support the finding of guilt of this defendant, which is Brandon Cody Phillips, beyond a reasonable doubt in this case. Now that's what I'm trying to say.
Clearly delineated.
And Your Honor, again, I do apologize, but if I can consolidate 2 through 5 into a more cohesive argument, I think you're going to find that the answers to 2 through 5, a lot of those are going to be affirmative, or a lot of those are going to run in my client's favor when I give you this argument, which is basically.
Okay, well, we can only go by your brief. What you argue here is up to you. I was
Yes.
just trying to get clarity for when the opinion is drafted and issued. But go ahead.
Yes, Your Honor. And if I may, the crux of this entire case turns a lot on the mens rea. Is it still alive in Tennessee? Was the mens rea proven in this case, and the actus reus too to a certain extent, for my client, Mr. Brandon Cody Phillips, to have been convicted beyond a reasonable doubt of especially aggravated kidnapping, aggravated child neglect, and aggravated assault? I know Mr. Saraceno, I'm trying to say it right, had argued in his brief that I didn't say anything anything about aggravated assault, but actually I did. It was
did.
three
You
different
did.
pages.
Each
I just
count.
said, it's the same argument, but essentially I'm trying to say that all of these things go together. Yes, there's insufficient evidence to convict my client, but also, Your Honor, these things are intertwined. Recently, in the case of State v. Edie, the Tennessee Supreme Court, that's found at 685 Southwest 3rd, 689. Yes, ma'am. EADY.
Very familiar.
Very recent case.
I wrote the dissent.
You certainly
In
did, Your Honor, and I think you're going to find
I'm very familiar. Yeah.
I think you're going to find on both of these that I think you wrote the dissent. But the first one I want to bring up is State v. Edie, because this really shows the direction that our Supreme Court's going, and I think the direction that we, the Court of Criminal Appeals and the appellate's courts are going, is you're looking at the mens rea. In that particular case, you found the jury, the state Supreme Court found that the jury had convicted the defendant on insufficient evidence, and there was a motion to sever involved. Now, that was a motion to sever offenses, not defendants, as was the case in my case. But it did result in a reversal because the Supreme Court said, and they agreed with you, Judge McMullen, that the jury in that case had been allowed to infer that that defendant was guilty just based on offenses that were improperly joined. I think it was a set
very
of
different.
robberies. But let's go on to another one, which is State versus Tony Thomas and LaRonda Turner. That
Another one,
also
that's
was
fine, yeah.
was the Tennessee Supreme Court this year. I think it was March, 687 Southwest 3rd, 223. Similar reversal reasoning was that the jury had convicted that defendant on insufficient evidence, which merely cast suspicion on that accused person. And just being present at the scene was not enough to convict Ms. Turner. And that, of course, had other issues that were important for us to know, but it did result in reversal. And that is essentially what we're arguing here, is we're asking you to look closely.
That was a very limited question concerning accomplice liability and whether there was sufficient corroboration of a co-defendant.
You are correct, Judge Mullen. But if I may, you did argue in that
I think
case.
Judge McMullen is also asking about criminal responsibility. So we start off the argument by saying, is mens rea still alive and well in Tennessee? And it is alive and well in Tennessee. Obviously, it's part of the statute.
But when we look at
we're not talking about a strict liability offense here, but in my mind, this comes down to, at least in part, a question over criminal responsibility.
You're exactly right,
And
Judge
so,
Greenholz.
in this case, if we're viewing all the evidence in a light most favorable to the state, I have the victim saying that the defendant is briefly hesitating. He's hearing her cries for help as her children are being taken away in her car. And as the state says at that point, then, your client has at least three choices. He could have entered the vehicle and essentially cut her ties off as it goes. He could have stopped the vehicle as it goes.
Which he did, Your Honor.
You know, in essence, the state is arguing that he allowed the escape to occur,
I understand this.
knowing that there was a crime in progress and that he sought to aid the crime. And so it's really not necessarily a question of mens rea as far as the elements of the statutes are concerned. Help me understand your position about why there is not criminal responsibility here on those facts.
Thank you very much, Your Honor. That is my point. Tennessee Code Annotated Section 39-11-402 has three components under which a person can be found criminally responsible for the conduct of another. If I can back up to one thing you said, or a couple things, Judge Greenholz. One was that we assume that my client heard these victims' cries for help. If you look at the victim's testimony, she's saying that he was actually behind another building.
It's not that we assume it.
Well,
it's that we construe the evidence in a light most favorable to the state.
You're correct.
And so we're not assuming anything. We're taking what she testified to, reasoning that in a light most favorable to the state, and drawing reasonable inference in favor of the state's case. And at that point, the jury could infer that the defendant, I think, from the testimony, could have inferred that your client heard her. And so that's why I'm taking that fact as a given. So let's take that fact as a given.
That's fine, Your Honor. And we're also talking about Scott County. This is not Memphis. It's not Chattanooga. Where the distance that these folks went was 0.2 miles. It was literally around the corner. And the testimony that we heard from officer that, trial counsel would have heard, I was not present then, from Officer Andy Davis of the Oneida Police Department, was that Amanda Phillips said when Brandon Cody Phillips, my client, got in the vehicle, he tried to get her to stop. He realized there were kids in the vehicle. He pulled her over, tried to pull her over and make her stop. He jerked the wheel. We also heard at sentencing the same thing from Amanda Phillips.
Closed the door and rode
Right.
away with him.
All
Well,
of these are facts that were rejected by the jury.
That's-
They were rejected, so you're arguing them
No, they
again.
actually, Judge Mullins, I don't think they were considered by the jury
McMullen. It's
because
Judge
Officer
excuse me.
Andy Phillips.
Counsel, it's Judge McMullen.
I am so sorry. What did
That's
I
okay.
call you?
That's okay.
I
She
did.
doesn't, I mean,
yeah.
obviously, she can take that with herself, but it's Judge McMullen.
I am
She's
so
presiding
sorry,
judge in this
Judge.
court.
Presiding Judge McMullen.
Yeah, so you're arguing facts
Okay.
that I think were presented to the jury and rejected. And your client was convicted of aggravated assault, especially aggravated kidnapping. So I'm a little, and I know you're compressing a lot of things, or all of the offenses. And I guess Judge Greenholz was trying to put it under the theory of criminal, not trying to, you did, to help you in conflating everything, because you haven't really attacked a single element of the offense that was not satisfied at trial. So you are, I want to be clear on this, you are attacking solely criminal responsibility?
No, Your Honor. I was trying to argue, he brought me to the point of criminal responsibility.
Okay.
So if I can argue that, it's that and the motion to sever.
Okay.
Those are the main.
Those are the two things that you're going to argue today?
No, yes, Your Honor.
Okay, all right.
Okay.
So I don't mean to cut you off, but, okay, so
No.
help me understand where the evidence was insufficient on the especially aggravated kidnapping.
Okay. On especially aggravated kidnapping, under criminal responsibility, Part 2 of that statute says you must act with the intent to promote or assist the commission of the offense. This is especially aggravated kidnapping. He had no knowledge of what was going on. The proof that the jury heard was that Amanda Phillips, his co-defendant, opened the door to the little Fiat and was screaming, "Get in, get in, get in." He came from behind a building, got in the vehicle on a wet, rainy night, and instantly, well, again, that's not going to be what the jury considered because that was at sentencing. But my point is, Your Honor, there was that testimony.
We have
And
to
if
ignore,
that-
don't we have to, Judge, I'm
and
sorry.
that testimony was prevented from coming in due to the motion to sever. You're right. You're right, Your Honor. And if I may, the other
Well,
part.
let me go back to that, because I wonder if we're leaving out important facts that the jury heard. So when you say that he had no knowledge of the kids in the car, that can't be right, because there is other testimony in the record that indicates that he had awareness, and that is the mom saying, "My kids are in the car.
Your
Help
Honor.
me." And so if the jury believes that testimony and can believe reasonably or infer reasonably that he heard that, then there is evidence in the record that he was aware of it,
But the
right?
mens rea, no, the mens rea means you've got to have the intent to commit the act.
I agree with that. You
Was-
had started off the argument by saying he had no knowledge.
Okay, so
And
what,
so there is evidence that he did have knowledge, right?
I disagree, but if we want to go to that, I mean, we're still talking about criminal intent. He's got to have the same criminal intent as the principal.
Okay, let me ask you this. How do you prove intent?
You prove intent by the surrounding facts. And the
Okay.
facts on Amanda Phillips were that she went up to the vehicle, looked at it on the rainy night, rubbed the window and all of that.
Well,
And-
but the point is, it's based on the facts. The jury heard all this, and they resolved the facts in this case.
I've got to go back to my motion for severance because I'm running out of time. I apologize, Your Honor. But yes, you're right, Your Honor. They should have been able to hear that. And if this motion to sever had not been erroneously denied, it would have been. If I can move on to number 3. Whether holding a hearing on a pretrial motion to sever behind closed doors without the defendant or the public present with no verbatim record of the same constitutes structural constitutional error, thus requiring automatic reversal. And then 4 and 5 are very similar. I'm just trying to narrow it down to what this injustice was and how it was caused.
Was there an objection to it
Yes, Your Honor.
at the time?
There was vehement and repeated objections.
Wait.
There were.
Okay, Judge Greenholz, and I'm going to allow you some time. He just asked you, was there an objection to it? Now, it, I'm assuming, was
I should
the
clarify.
motion to sever, to conducting aspects of the motion to sever
Behind closed
in
doors.
chambers.
Right. Was there an
Now,
objection to that?
I did not see any objection to that, Your Honor. I will note that Mr. Huff, who represented my client at the time, he's very soft-spoken and doesn't always speak up where the audio can pick him up, but I don't see any objection on the record.
Well, you're not suggesting that there was an objection that wasn't
No,
lodged
no, Your
on the
Honor,
record.
and I'm not suggesting that either,
Then-
but I am saying that there is also a way that Judge Sexton always handled things in
Okay.
court.
Ms. Salmons, again, this is your first time arguing before us.
Yes.
We only go by what's in the record.
Okay.
So
In my,
But let me ask, wasn't this renewed on the record later?
that's what Mr. Sarasano says. But, Your Honor, I asked you to look at whether 14C2 was ever considered. Was the argument that this was unfair to my client ever considered? And one thing I wanted to say in response to what Judge McMillan raised was that there is a statute that requires court reporters to be assigned to the court.
Let me just say this.
Okay.
And again, I understand you have 7 minutes of rebuttal. Okay, what was striking to me about your brief, again, aside from the various deficiencies and the difficulty in following your issues, was that you make various procedural attacks regarding the in-chambers discussion, but you don't really identify what was discussed. And you don't challenge the substance of the denial of the motion to sever. So in reality, it makes no difference whether any of those procedural things were violated because you don't challenge the trial court's determination to deny the motion to sever. Is that accurate?
No, Your Honor. If that is
Or you
accurate.
didn't argue it in your brief.
If the part that I did not challenge the decision on the motion to sever is accurate, then I respectfully disagree because that's the one thing that I'm here for today. I'm saying that Rule 14C2, and that's what I put in my brief, I believe.
No. Well, then I need to see that.
Because that's what we also argued on our motion for new trial before Judge Walden was that Rule 14C2 is a different subsection than anything that was considered. Judge Walden even said the Bruton issues, it refers to Bruton issues. There were never any Bruton statements involved in this particular case. None of the statements were exculpatory to my client.
Issue,
I mean, were
indulge me,
inculpatory. They were.
Mr. Cicinero? Sarasano. Ms. Salmons, identify the issue
Okay.
that you attacked the substance. You challenged the trial court's motion to sever
In my brief?
in your brief.
Okay. Yes, ma'am. It's on Rule, let's see.
Actually, I'm going to give you time to find that, and you can address it on rebuttal.
It's page 45 is one of the parts at the top. Says 45C2 requires severance where appropriate to promote a fair determination of the guilt or innocence. Also in my,
Hold on 1 second. You said where?
page 45 of my brief. And also in Mr. Sarasano, when I replied to his brief,
Was it in was it included in your statement of the issues?
it was included in my initial statement of the issues. Do I do a different one each time I do a reply?
Okay. So page 45 and what other pages? Because that was my fundamental confusion. You spent a lot of time on other things, but I didn't get much analysis, authority, or anything on why the severance was improper.
Okay.
But you can have your seat, Ms. Salmons.
Oh, I am over time.
And yes, you've got 7 minutes on rebuttal, and we can address that then. I'll allow the state now to continue with their argument.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Johnny Sarasano on behalf of the state of Tennessee. I think as opposing counsel has mentioned, there are basically two sort of broad issues, one being sufficiency of the evidence, the other being this off-record severance hearing. I intended
Do you agree, was it a severance hearing? Because it was confusing to me, and I've tried to read to swallow the record. There's a lot going on in this case. But my reading of the record was that the trial court had a hearing, and it preceded the in-chambers discussion. the in-chambers discussion was to clarify, for purposes of defense counsel and the state, what statements the state intended to use at trial. Okay, so there was a hearing, according to the trial court, prior to the in-chambers, what I would call discussion. Then there was more discussion following that hearing. And then during the more discussion, the trial court said, hey, I don't want to really just make another determination off this. Why don't y'all, let's meet up, and the state, you decide what you're going to use, what you're not going to use. And because there was a problem with logistics, there was another judge using the courtroom or whatever, the in-chambers discussion took place. There was no proof conducted during, or no, elicited during that hearing. It was, from what I understand, the only person who survived, when I say survived, who was present, because you had a successor judge in this case, you had successor defense counsels in this case. The only person who was consistent was the prosecutor.
I believe that's correct, Your
Okay.
Honor. And I think I have a similar understanding of the facts regarding severance. I can focus on that issue for just a second and sort of reiterate some of those facts that you just mentioned. Yes, there was a pretrial motions hearing. At that time, there was sort of the issue of severance was raised, and I think what you're touching on there, Your Honor, is there were some brutal concerns, sort of these concerns about maybe inculpatory they statements, and so that was, I think, part of the impetus for the desire to sever the trial.
Let's be clear. The motion to sever alleged both grounds. They wanted to, was it the one based on the brutal as well as fairness? The motion to sever was very broad. So I couldn't tell from what the trial court, what was captured in the record submitted on appeal, what the actual hearing, it appears there was an actual hearing that we do not have in the record. That's separate and apart from the in-chambers discussion. I don't know what grounds the first trial court denied the motion to sever upon. That was Judge Sexton. So I don't know what grounds he denied it on. I do know subsequently when he readdressed it, he just summarily said denied. So you may continue.
Thank you, Your Honor. I believe that the court, during the on-record severance hearing, I think the parties discussed, again, these inculpatory they statements as well as some potential testimony from the co-defendant. It was my understanding at that point that the trial court said, in response to the state's representations, that they didn't think that there would be they statements. It said, I'll monitor the issue. So it sort of decided to consider that throughout the trial, and it said that it would consider the issue throughout the trial, and then it sort of took a wait-and-see approach regarding the co-defendant's potential testimony, what that might elicit. And so turning to the arguments on appeal, given these facts, defense counsel or defendant has raised the issue of this sort of structural constitutional error. I think at this point, just on this issue generally regarding the severance hearing, the issue is waived. There was no objection to the in-chambers hearing. There was an offer, or there was a mention that the court reporter didn't need to be there. This is not something that the state encourages, of course.
Yeah, if it was a hearing, if there were determinations, is that a problem?
I don't think so, Your Honor. I think under plain error review, the first problem is for the defendant is that there's no breach of a clear and unequivocal rule of law. And I think this sort of goes to your question. The defendant has raised this issue like it's a concern about a public trial right.
And open courts.
Pardon?
And open courts. So
And,
you're
yes.
not suggesting, surely the state's not suggesting that the trial judge, and look, this is a good trial judge. We have no basis in the record to infer anything malign at all. That said, surely the state's not suggesting a trial judge could just simply hold hearings back in chambers without the presence of a court reporter. make findings of fact and determinations of law, and that be sufficient. We're not suggesting that.
Your Honor, no, I don't believe that is what the state is suggesting here. I think it's important to highlight, too, that there wasn't any evidence presented at this particular hearing.
How do we know? Because there's no transcript, right? So how do we know what was said? I know that there's not an objection in the record, because I can look at the rest of the record and see there's not an objection, but how do I know what occurred back in chambers?
To some degree, Your Honor, we don't. What we do have regarding the nature of what was contained in that hearing, what little we do have, is that the parties agreed when the court asked, will there be evidence presented? The parties said no, there's not going to be witness testimony, there's not going to be physical evidence presented. They agreed explicitly on the record that it would just be argument. So that is all we have. But in regards to the fact that we don't have a record, I think it's important to highlight this court's holding in State versus Bolden, that ultimately the burden to create a complete record lies at the feet of the defendant.
That's right. I mean, the state's strongest argument here is a waiver argument, isn't it?
Yes, Your Honor, I do believe so. And I think that goes, I think Bolden sort of is in large, is part of that argument, because there isn't a rule of law really on this issue other than Bolden and the binding case law that Bolden cites to, namely that it is ultimately the defendant's burden to create a complete record. Sort of turning back to the constitutional, structural constitutional argument, there's certainly no rule of law on the question of whether a in-chambers severance hearing with just argument is like a public trial, and so there's no breach because there is no rule of law on the subject. Certainly not in this jurisdiction. I didn't see anything.
The open courts provision doesn't cover it?
Pardon, Your Honor?
The open courts provision would not cover it?
I'm not sure. I'm not sure entirely.
Okay, I mean, you're making the representation that there is no law that governs it, but Article 1, Section 17 does not cover it?
I'm not sure, to be honest with you, Your Honor. Regardless of the first plaintiff.
I'm just really confused as to why we do not have a transcript of the denial of the motion to sever. It doesn't exist.
Certainly, Your Honor.
And I mean, I understand your argument of waiver, it's their duty to bring it, but it just
Why
doesn't
did this
exist.
happen?
So are we to presume that that's what occurred in chambers?
That there was just a sort of an arguments-based hearing?
Yeah, and that the trial court made an off-the-record finding?
Yes, Your Honor. To that point, when the motion was renewed on the record, the trial court said, "Didn't I already rule on this?" And seemed to affirm that it had.
And from that, we have nothing. We have no, because there are two sections. Again, I'm going back to the defendant filed a motion to sever, which argued severance on multiple grounds, and so I am looking for. I know it's their burden once again to demand a hearing on it and to demand a ruling from the court on both issues. And that was covered in the motion for new trial. But we have no findings of fact. Are we just supposed to go off of what the successor judge did in the motion for new trial? And she or he, I don't remember, but they covered it extensively.
Your Honor, I do believe that, unfortunately, we do, I think, need to lean on what occurred at the subsequent on-record hearing. At this point, it might be worth mentioning that under Rule 24, Rule of Appellate Procedure, Rule 24C, that there could have been a statement of evidence made that this court could have considered. Perhaps some fact-finding in that regard would have been helpful. However, that hasn't occurred either. And so I do believe you're correct, Your Honor. All we have ultimately is some references to what happened at that hearing and sort of not particularly clear terms, but then the subsequent on-record hearing where the court addressed what the parties raised about severance, namely the co-defendant's potential testimony and the concern about the Bruton concern, I believe that was about these they statements.
Does the propriety of the trial court's ruling on the motion to sever matter in this case?
I don't think so, Your Honor. I think for one, I don't think it matters in part because the issue is waived.
Oh, you're saying waived on what grounds?
Waived because there was, I would argue that there was waiver because I don't think on appeal in the principal brief that the issues were really discussed in any meaningful detail, and so.
So it's a failure to argue in the appellate court waiver and not a failure to preserve in the trial court waiver?
I think so, Your Honor. I think there wasn't any objection or.
So that's a failure to preserve in the trial court waiver, right?
Pardon, Your Honor?
That's a failure to preserve in the trial court waiver, right? I mean, there are two types of waivers.
I think it's a both and.
One, you can waive it in the trial court, and then two, you can waive it in the appellate court, even if it were preserved below. So I'm kind of curious now. I thought I understood what the waiver argument is. To Judge McMullen's point, what's the waiver argument?
The waiver argument regarding the off-record hearing, is that what we're talking about here? I apologize.
No, I guess my original question was, does the propriety of the denial of the motion to sever matter? And your response to me was no, because it's waived. And so then Judge Greenholz followed with, which waiver? Did defense counsel fail to preserve it below? Or did they fail to argue it on appeal, or both?
There wasn't any objection made to the trial court's ruling at the on-record hearing. And then on appeal, I would say that the issue, I didn't elucidate that we were getting to the merits of the issue in the principal brief.
Okay. The other question that I ask is, so I couldn't tell from the record because there was a lot of short talk in the transcript whether defense counsel agreed to the ultimate outcome of whatever happened in chambers, okay? So let's say, for example, the state said, hey, so we are talking about a Bruton question. We're not going to use this. And defense counsel said, oh, I'm good. So, you know, I guess your answer to that is going to be, well, they re-raised it pre-trial on the record. So I'm answering my own question. Never mind. Moving on.
Makes it easy for me, Your Honor.
So let me ask you, with respect to the waiver, though,
Certainly.
I understand you're arguing plain error factors.
Sure.
Appellant doesn't request plain error review. Why are we talking about plain error?
I
Cases
think
from this court have made clear that if it's plain error, you raise it and argue it just like you do any other issue. It's not something you raise in a reply brief. It's not something you raise for the first time at argument. Why are we talking about plain error?
I think for the sake of thoroughness, Your Honor, and the fact that it was raised, the concern about general concern about structural constitutional error.
That's fair enough.
I just
Okay.
wanted to make sure I touched on those issues, just for the sake of both clarity and thoroughness, Your Honor.
Fair enough. Thank you.
If I may turn back to the, unless this court has further questions.
No, you may proceed. I don't.
I'll turn to the sufficiency issues. Just to touch on the facts, I think just for the sake of clarity, very briefly, Ms. Hibbard drives to this Mexican restaurant with her 2 children in the back seat. She goes in to get the food. While she's getting the food, the co-defendant in this case steals the vehicle. Ms. Hibbard tries to stop her, yells, "My children are in the car, my children are in the car." This is a constant refrain through this exchange. She tries to get in front of the vehicle. It swerves around her. She grabs onto the door. It slips away. Then it pulls forward. At this point, the defendant comes on the scene running from the same side of the building that Ms. Hibbard testified that the co-defendant had appeared from, comes from the right side of the building running towards the vehicle. Ms. Hibbard testified that she believed that this particular individual might have been a good Samaritan, so she says, "Help, my kids are in the car, my kids are in the car, my kids are in the car." She's yelling, shouting, screaming at this individual, hoping that he will come and come to her aid. Simultaneously, the co-defendant opens the door to the vehicle and says, "Get in, get in, get in, get in," urging the defendant to join her in this kidnapping. The defendant gets to the vehicle, hesitates, seemingly acknowledging the choice that he has to make, and decides to get in the vehicle. At that point, Ms. Hibbard testified at trial that at that point she had 2 more seconds she could have gotten inside the vehicle to try to prevent the kidnapping from being successful. Unfortunately, because the defendant chose to enter the vehicle at that time, the kidnapping was in fact successful.
So let me ask you this. So let's take off the table, just for sake of argument, that the defendant did not prohibit or prevent the victim from rescuing her children. Let's take that off the table. Is there any other basis to hold the defendant directly liable for any of these crimes or criminally liable for any of these crimes?
Are you saying other than a theory of criminal responsibility?
I'm taking what I perceive to be your best fact off the table to see where the
Certainly.
argument goes. If there's not an obstruction to the victim regaining her children, is there any other evidence that this defendant is either directly responsible for those crimes or is criminally responsible for the crimes? In other words, does the entire argument hinge on the jury finding that the victim was obstructed by the defendant's actions?
No, not exactly, Your Honor. I think there's another sort of independent ground that this court should consider as an important factor in deciding that the defendant was criminally responsible. Namely, it's not just that he entered the vehicle at the apex of the kidnapping, but also that he acted in conjunction with the co-defendant before, during, and after the crime. So it's not just the entry into the vehicle, and this court has held that such actions where people engage in mutual conduct both before, during, and after a crime is indicative.
Okay, we have presence. Do we have anything else? Do we have planning? Do we have facilitating, the methods of escape? Do we have planning the tools of the crime? Do we have anything other than just presence beforehand?
I think it could have been inferred. I think the jury could infer, certainly viewing the evidence in the light most favorable to the state. The defendant came from the same area that the co-defendant came from. He entered the vehicle with co-defendant. This seemed to be a coordinated effort by nature of the anticipation that the defendant would be there. They flee the vehicle together. There is testimony of that in the record. And then the next day, they are seen walking around town together, at which point they are arrested. And so I think that is another ground by which this court could find that the defendant was criminally responsible for the underlying conduct beyond just sort of the timing and the critical nature of getting into the car precisely when he did.
Okay, and I'm sorry to keep asking the questions.
No, go ahead.
If the defendant does not prohibit the victim from regaining access to her children, and once again, this is a counterfactual hypothetical to the state's
Certainly.
theory of the case. If that doesn't happen, defendant gets into the car, they leave. For criminal responsibility, not only do I have to have the intent to engage in share the same mens rea as the defendant, but there also has to be some aid, has to be some direction, has to be some ordering, has to be some a little more than facilitation, I guess, as it goes. Where is that fact here? So I see that clearly where the defendant keeps the mother from regaining possession of her children. If that fact's off the table, where is the other evidence of aid?
Beyond, so if we take the fact of the entering in the vehicle out of the equation, what else is there?
Because at that point, it seems like it's mere presence. Because it doesn't seem, and this is what I want to discuss, it seems like it's mere presence that the defendant's not doing anything to aid the crime. Crime's already occurred, he's getting in the car, he's leaving. Outside of him prohibiting the mother from regaining control or custody of her children, how is there aid otherwise?
To some degree, I think you make a good point, Your Honor. I think what I'm arguing is that the aid is sort of implicit by nature of this acting in conjunction with each other. So do we have any direct evidence of aid? If we take that fact off the table, I think that becomes a much closer question, Your Honor. Fortunately, I think that fact is still relevant, but even in the absence of that fact, I think it is more than mere presence. I think them acting in conjunction throughout, again, before, during, and after. I think the fact that the defendant comes from the same location as the co-defendant indicates, or the jury could have inferred that there was some planning involved, that he was monitoring the situation that he joined precisely when he did. Again, that, although I guess we're taking that from consideration here in this hypothetical, but leaving the vehicle together, abandoning the children, escaping in the woods, eluding law enforcement together, and then being caught together, I think suggests, perhaps not directly, but I would argue implicitly, that seems to indicate that they were, in fact, that the defendant was criminally responsible and was implicitly aiding in the kidnapping of these particular children.
Thank you, counsel.
See, your time is expired. You can either close or, you can close.
Thank you, thank you, Your Honor. I just ask that this court would affirm the convictions. Thank you.
Thank you, counsel. All right, Ms. Sammons, you're up. You've got your 7 minutes.
Thank you, Your Honors. Just to talk about criminal responsibility, if I can, for a moment. Subsection 2 and 3 of the criminal responsibility statute allow a couple of different ways that somebody can be criminally responsible for the conduct of another. Y'all talked a little bit about aiding and abetting, but subsection 3 is, I think, what's key here, because that motion to sever was erroneously denied. Because if a person has voluntarily undertaken to prevent the commission of the offense, but they act with intent to benefit in the proceeds or the results of the offense and to promote or assist in its commission, if they then fail to make a reasonable effort to prevent the commission of the offense, then and only then can they be found under the third prong, criminally responsible for the conduct of another.
Well, I mean, how was the criminal responsibility charged? That wasn't charged to the jury, was it?
I did not see it in the
that aspect, that theory of criminal responsibility wasn't charged to the jury,
I believe
was
you're
it?
correct, sir,
All right,
because
so
it
how
was.
was it charged? How did the trial court charge the jury on criminal responsibility?
I don't know that they did. I mean, surely it was contained in there, but I looked at it I didn't look at it for, I gleaned over the instructions.
You would agree that we would consider the same theory of criminal responsibility the jury was charged with, correct?
Yes, Your Honor, and
Okay.
I think it might have only had 2 in it, but I could be wrong. If it had anything in it, I don't remember seeing criminal responsibility in there. But my argument is that because the motion to sever was erroneously denied, that was not allowed to come in,
Okay,
is
so-
all I wanted to say, is that these things are intertwined. My argument about the insufficiency of the evidence, a lot of it comes from the fact that the motion to sever was denied.
All right, so let's talk about that. I
Yes.
went to your brief. So your statement of the issues number 4 is not the same as your number 4 on page 43, where you directed me to page 45 as to where you discussed why the trial court's ruling in denying the motion to sever was improper. But you don't tell me anything about why the trial court's ruling was improper, other than an alleged misapplication of the standard of review. And you do not address the trial court's subsequent or successive trial court's ruling on both grounds that were alleged in the motion to sever. The successive trial court did everything on the record and gave a very extensive order denying your motion for new trial, none of which you challenge here. So I have 2 questions or just concerns. If you appear before us again, Ms. Sammons, I just need you to pay particular attention to your statement of the issues.
Yes, ma'am.
Because that is how I prepare, as well as your case authorities that you submit. Because when I said I didn't see you attack the substance of the motion to sever, as this brief is written, you don't. So you kind of do it as an afterthought. You can't put an issue within your brief and expect us to address that issue as an issue presented. So that's just for future advice. It will be considered waived every time. So tell me, this is your opportunity to tell me why the successor trial court got it wrong.
And I sure didn't mean to do it as an afterthought, because I do think it really runs on the crux of that.
I think it's critical to your case. It
Right.
probably should have been up at the top 3.
And in my reply brief, I did discuss it on, and again, you're going to think I didn't discuss it at all, but I brought it up on page 2, 3, 13, 15, 19, and 20. And the reason is because I do think, Judge McMullen, that that's something that's misunderstood. when the initial trial counsel filed his motion to sever, he included something about statements. We know that. And I think that Judge Walden, who's the successor judge, assumed, and as Mr. Sarasano has, that it was a brutal issue because they've referred to it as a brutal issue. I don't believe in reviewing the trial court record that the trial judge ever referred to it as a brutal issue. He referred to it as an issue about statements. And the reason I say that, Your Honor, is because the statements to which he was referring are a statement of Amanda Phillips to the police that Brandon had nothing to do with it, that he didn't know what we were doing, and he tried to pull me over and tried to get us to pull over, and we did. And the statement from Cody Phillips to the effect of the same thing. In other words, these two statements are not inculpatory toward Brandon Cody Phillips. To the exact opposite, they are exculpatory, which makes them not essentially brutal issues for Brandon Cody Phillips. And Brandon Cody Phillips, Your Honor, is the only defendant in this case who filed a motion to sever. I think that's important to note. At least he's the only one on the record that anybody's discussing that I can hear. I think maybe Mr. Stewart was late on Amanda's to show up and the judge wouldn't hear it. But my client's the only one who has insisted from the beginning that there's more than just an issue of I'm innocent. It's also that, in fairness to me, I don't want the jury to hear that I was with this person who stole a vehicle with kids in it. That has been the entire thing. Judge Greenholtz had a case in 2023, and I believe the guy's name was Montreal Pontus Robinson, and he had committed a felony murder, and there was a stolen Camaro and so forth. He overturned the conviction for theft of the Camaro because there was no proof. I mean, Mr. Robinson wanted to kill the guy, sure, but he didn't want to steal his vehicle. So my point is that...
That wasn't at all what Robinson held. That's not at all
Okay.
what Robinson held. No,
I
Mr.
could be-
Robinson did want to steal the vehicle.
Okay.
The state was arguing in that case was because the victim was tied up and bound in the back of the vehicle itself, that the victim was still in constructive possession of the vehicle. And this court said, respectfully, no.
Right.
There was always an intent by Mr. Robinson to take that vehicle, or so this court found. That's not at all what Robinson held.
Oh,
counsel.
I'm sorry, I misunderstood.
That's okay,
then.
that's okay, but that's not at all
my
what
point
Robinson
is
held.
that I guess the intent is what's the plan, and there was no theft plan in this case. There was no, and there certainly was not proven to the jury. And because of this erroneously denied motion to sever, that we can show on the record no place on it where Judge Sexton ever considered fairness to the defendant.
The successor judge did, and you haven't told me why that successor judge is wrong.
Because of the statements that show that, to the contrary, on criminal responsibility, my client did do something to stop the kidnapping. It was literally, if you look at the page 158, I believe, in the transcript or whatever y'all call the technical record, there's the 911. 603, or 1803, the police are called. 1809, the police are at the vehicle with the kids. So we're talking about a 6-minute interval that was only prevented because my client jerked the wheel. Now, number 5 of my issues is whether the trial court's failure to comply with the mandates of the Constitution or the Tennessee Rules of Criminal Procedure, which require these verbatim recordings and so forth, caused an injustice or prejudice in the present case, thus entitling the defendant to a new trial. I would respectfully submit that even if you don't find structural constitutional error, there is certainly plain error here because the evidence was insufficient to convict Mr. Phillips.
All right, thank you so much. I see
Thank
your
you.
time has expired. The case will be taken under advisement. Are we done?
Thank you both. Thank you.
Madam Clerk, do we have any other cases for the morning docket? No. All right, we're in recess until 1:30.
All rise.